The power to pardon is one of the most extraordinary authorities granted to the President of the United States. And with that being said, President Biden has just pardoned his son Hunter a full and unconditional pardon for those offenses against the United States which he has committed or may have committed or taken part in during the period from January 1st, 2014 through December 1st, 2024. And I guess the real question is, why not pardon him for 20 years? Or even a lifetime pardon to absolve him of all crimes, past and future? Is that even possible? Are there any limits to this power? To answer these questions, we first need to know, what exactly does the Constitution say about this power? What does a pardon actually do? And why did the framers of the Constitution believe it was so important to include? All of these are great questions that we are going to answer, so let's get right to it. The power to pardon is enshrined in Article 2, Section 2 of the Constitution, which states, "The President shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment." This means the President can forgive federal crimes, removing any punishment or legal consequence. Now, this authority does not extend to state crimes or to overturning impeachments. And just in case you were wondering what the difference is between the two, the distinction lies in which government level defines, prosecutes, and punishes the offense. Federal crimes are offenses that violate laws enacted by the United States Congress, or crimes committed against the federal government or its interests. Examples of federal crimes might include tax evasion, an immigration offense, federal drug trafficking, or mail-and wire fraud. These crimes are prosecuted in federal court by federal prosecutors and investigated by federal agencies like the FBI, the DEA, and the ATF. Federal convictions typically result in sentences served in federal prisons. State crimes, on the other hand, are violations of laws created by state legislatures and apply within the specific state's boundaries. Some examples of state crimes might be assault, theft, murder, drug possession in small amounts, traffic violations, DUIs, domestic violence, stuff like that. These crimes are prosecuted in state courts by state or local district attorneys and are investigated by local or state law enforcement. Punishments are determined by state law with sentences served in state prisons or county jails. Okay, where were we? Right, Article 2. So there are many unwritten powers that the president has. Things that were not expressly written in Article 2 of the Constitution, but things that are implied that a president can do in order to fulfill the role of chief executive. The power to pardon is not one of these. It is listed plainly in black and white, with only one limitation. If you're president, you can't pardon yourself in an impeachment. And before we go any further, what exactly does a pardon do? A pardon is a specific form of clemency that forgives a crime and removes any remaining legal penalties associated with it. A full pardon restores civil rights that may have been lost due to a conviction, such as voting rights or the ability to serve on a jury or hold public office. It does not, however, erase or expunge the conviction from a person's criminal record unless explicitly stated by law. The purpose of a pardon often serves as an official recognition of forgiveness and rehabilitation. Now, clemency is a broader term that encompasses various actions a president can take to reduce the impact of a criminal conviction. And there's multiple forms. First, there's the commutation of sentence, which reduces the severity of a punishment, like death sentence to life imprisonment, without nullifying the actual conviction. There's also a reprieve, which temporarily delays the execution of a sentence, often to allow time for appeals or additional review. Then there's amnesty, which is a pardon extended to a group of individuals, typically for political offenses. And then there's remission of fines or restitution, which cancels or reduces financial penalties associated with a conviction. An act of clemency oftentimes is less comprehensive than a full pardon and does not necessarily restore all civil rights. Now, knowing this, Biden has issued the full pardon to his biological child, which includes crimes he may have committed over the last decade. Let that sink in. So, what the heck were the framers of the Constitution thinking when they added this power? Well, for starters, they were inspired by English legal traditions, where the king could issue pardons. The framers saw this as a crucial tool for justice and mercy. Alexander Hamilton explained his reasoning in the Federalist number 74. Humanity and good policy conspire to dictate that the benign prerogative of pardoning should be as little as possible fettered or embarrassed. This essentially means that the power to grant pardons should be kept simple and free from unnecessary restrictions, as doing so would limit its usefulness in addressing injustices or promoting mercy. He goes on to mention that the pardon power could help heal national divisions and address injustices that might arise from rigid laws. Some might say that this power should be in the hands of the legislature, a group of lawmakers who could discuss and weigh the options of clemency and forgiveness. Hamilton insisted that a single executive was better equipped than a legislative body to exercise the pardon power. Legislatures might be too slow or divided to act effectively in situations requiring urgent decisions. Now, at the Constitutional Convention, this is something that's on their minds, right? People are unhappy and they're fighting back against the government. And Hamilton's reasoning is evident in George Washington's pardons during the Whiskey Rebellion, which Hamilton himself supported as a member of Washington's cabinet. Okay, that's great. Hamilton's great. But we know there was this other group at the Constitutional Convention that was strongly opposed to giving too much power to the national government. A group much bigger on states' rights and the rights of the people. The Anti-Federalists, the ones who refused to sign the Constitution unless a Bill of Rights was added, took major issue with the presidential power to pardon criminals. They feared it could be abused and lead to corruption, undermine justice, and consolidate excessive power in the executive branch. Here are their concerns listed. They worried that the pardon power could be misused to shield allies of the president, or those who had committed crimes on the president's behalf. They argued this power might be used to cover up wrongdoing, particularly in cases of treason or corruption. An anti-federalist writer, Brutus, warned, "The president ought not to have the power of pardoning because it may sometimes be exercised to screen from punishment those whom he had secretly instigated to commit the crime." They also believed that allowing one individual to override judicial decisions could weaken the rule of law. They feared that this power could send a message that justice was negotiable, eroding public trust in the legal system. Now, the Anti-Federalists saw the broad scope of the pardon power as a tool that could be exploited by a despotic president. They worried that it placed too much unchecked authority in the hands of one person, which they believe contradicted the principles of checks and balances. They argued that pardoning power should either be limited or shared with Congress to reduce the likelihood of abuse. And Anti-Federalists were particularly alarmed by the idea that the president could pardon individuals convicted of treason. They feared that a president might conspire with traitors and then pardon them, potentially endangering the nation's stability. In the Federal Farmer number 16, an Anti-Federalist essay, the author cautions, the power to pardon treason is a very dangerous one, and it may be used for improper purposes. Finally, they were critical of the fact that the pardon power was essentially unchecked, with no requirement for the president to consult Congress or provide justification for pardons. They felt this lack of oversight left the door open for arbitrariness and favoritism. Ladies and gentlemen, the Anti-Federalists. Okay, well, we've heard both sides of the argument for giving the executive leader this power. Let's move along and talk about this more recent presidential pardon Biden has issued. For starters, it is the first time in history that a president has pardoned their own biological child. I don't care what you've heard in the news that this sometimes happens. This is historic. Who cares about Bill Clinton's crackhead half-brother? The best part is, Biden's not done. Typically, a president grants pardons and clemency at the end of their term, because as we relearn every 4 or 8 years, it's not very popular with the public. So, what is the limitation of the power to pardon? Biden has extended over a decade's worth of clemency and full pardon to his son. Is it within the realm of possibility for Biden to absolve his son of all crimes past and future? This is something that we just do not know, and something that will need to be interpreted by the Supreme Court. As the executive power continues to expand in America, we see more and more instances that just have no precedent. We just don't know what will happen or what can be done because the Constitution itself is so vague. There are no limitations written other than the one about impeachment. And in this case with Hunter Biden, the son of Joe Biden, there is no impeachment. So by all accounts and technicalities, yes, he could do this. Now, if we the people really stood up and said we don't like this, there could possibly be a way to change this through the amendment process. We would actually have to change the document to add these stipulations, further limiting the power to pardon. I have somewhat recently made a video on state conventions and how specifically the states can get involved in writing their own amendments. Check it out if you have time. But other than that, as stated, it is virtually a limitless power. Okay, that's it for now. Thanks so much for sticking to the end of my video. I hope you enjoyed it. I hope you learned something. We'll make more videos soon.